Good morning, good afternoon, and good evening. On behalf of the organizers for this session, the Pangingisda Nating Gawing Tama Network, the Tambuyog Development Center, the Philippine Association for Intercultural Development, the Philippine Indigenous Community Conserved Areas Consortium, Rare Philippines, and the Center of Maritime Reform for Humanity from Indonesia, I would like to thank all of you for being with us today. Maraming salamat po. We have a very interesting topic for today. In preparation for the International Year of Artisanal Fisheries and Aquaculture in 2022, and in due recognition to the valuable contribution of men and women, small-scale and indigenous fisherfolk to food security, employment generation, and cultural solidarity, especially in Southeast Asia, we thought that the topic on tenurial system of small-scale and indigenous fisherfolk is relevant and timely. It is relevant because of the several challenges that face fishing nations in the world, the wicked problems on overfishing, illegal, unreported, and unregulated fishing, and climate change, which tend to displace a significant number of fisherfolk, not only in Southeast Asia, but in the world. It is timely since the COVID-19 pandemic exposed the vulnerabilities of this sector as disruptions in production and distribution have adversely affected many of our fishing nations. We will be having our session for 1 hour and 40 minutes, and we are very fortunate to have 3 panelists, 2 from the Philippines and 1 from Indonesia. Our initial design is to make this a live session. However, because of circumstances that are beyond our reach, we decided to make it blended. Our panelists have pre-recorded their presentations in order to prevent any technical difficulties due to internet connectivity. However, our panelists will be with us live during the open forum. I will be hosting today's session on small-scale tenurial rights in Indonesia and the Philippines. My name is Dennis Calvan, and I work as a senior manager for policy and government initiatives at RARE, a non-government organization that partners with more than 60 local government units to establish managed access areas and reserves and savings clubs. We aim to help our partner fishing communities to develop core behaviors for sustainable fisheries, namely, for them to fish at the right place and at the right time with the right fishing gears, to report their catch, to participate in community meetings, and to register. We are part of the Panagat Network, which is a loose coalition of non-government organizations and fisherfolk organizations in the Philippines to ensure that fisheries laws and policies are enforced. Many of our member organizations practice community-based coastal resources management, or CBCRM, where at the heart of it is to secure tenurial rights for small-scale fisherfolk. We are very fortunate to have with us today 3 distinguished panelists. We have here with us Mr. Abdul Halim from the Center of Maritime Reform for Humanity from Indonesia. We also have with us Ms. Dina Umengan of the Tambuyog Development Center and Mr. Dave De Vera from the Philippine Association for Intercultural Development. Our distinguished panelists will answer 3 basic questions on the tenurial system for small-scale and indigenous fisherfolk in their own countries. First, we all wanted to know whether tenurial and customary rights are legally binding in Indonesia and the Philippines. This is very important as we will know the legal basis for claiming rights to utilize resources, for example. For the next several minutes, we will also be informed whether existing tenurial systems do benefit the small-scale and indigenous fisherfolk, and in what form do they enjoy them. This is very important so that we can justify that giving tenure to small-scale and indigenous fisherfolk have positive impacts to warrant replication and support. Then we will likewise be informed on what recommendations do our panelists have in order to strengthen existing tenurial system in order to ensure that they are optimized by the people and the communities who depend on the natural wealth of the sea. To start the ball rolling, I would like to introduce to you Mr. Abdul Halim, the current Executive Director of the Center of Maritime Reform for Humanity from Indonesia. The Center of Maritime Reform for Humanity is an independent think tank and policy advocacy groups that supports the government of Indonesia by providing evidence-based policy making on promoting sustainable and responsible fisheries management that is free from the practices of human trafficking and modern slavery, strengthening small-scale fishing communities' rights and fish workers overseas. Let us all welcome Mr. Abdul Halim.
In order to celebrate the World Ocean Week, the Center of Maritimes for Humanity, together with other organizations, we have a special topic for discussion, that is small-scale fisheries, tenurial rights in Indonesia and the Philippines. To guide our discussion, our session, the moderator have give us 3 questions. First question has 2 points. The first point is, are tenurials and customary rights of small-scale fishers and indigenous fishers legally recognized in your country? Before answering this question directly, let me show you some information. We acknowledge that small-scale fisheries are globally important. They are providing food security and livelihood for local communities, including millions of small-scale fishers and their families. In the latest of FAO landing statistic, in 2020, Indonesia is the 3rd greatest marine capture producers with a total production of 6.71 million tons in 2018. Ministry of Marine Affairs of Fisheries of the Republic of Indonesia reported that Indonesia has 2.7 million of fishers, and 90% of these are small-scale fishers. We call it in bahasa nelayan kecil, and including indigenous fishers, or in bahasa we call it nelayan tradisional. Back to the first question, are tenurial and customary rights of small-scale fishers and indigenous fishers legally recognized in our country? To answer this question, we should look it first into our constitution. Based on our constitution, especially in Article 18B, amendment of our constitution, mentioned that the state recognizes and respects the units of customary law community and its traditional rights as long as it still exists and in accordance with the development of society and principle of the Union State of the Republic of Indonesia that is governed by law. In other article, 28I, paragraph 3, mentioned that cultural identity and traditional community rights are respected in accordance with the development of times and civilization. So based on our constitution, we could answer that our small-scale fishers and indigenous fishers tenurial and customary rights are recognized in our country based on our constitution. The second point of the first question is how are they granted to this group? If we look back to the Indonesian constitutions, as mentioned before, that the state recognizes and respects the units of customary law community and its traditional rights as long as it still exists. So based on the facts nowadays, we could mention that in western and central part of Indonesia, such as Aceh and North Sulawesi, local communities have been practicing communal control over access to natural resources in coastal areas, whereas in eastern part of Indonesia, such as Maluku Islands and West Papua, there are stronger traditional community claims have been applied not only to control access to resources but also to own proportion of certain territories, including waters and land in the coastal areas, including the natural resources therein. So based on these constitutions and the facts that they are still exist, so small-scale fishers and indigenous fishers in some areas of Indonesia who are still exist, they are granted by our national regulations, especially our constitutions, that they could implement their own rights in terms of tenurials and customary marine rights in Indonesia. The second question is how does the small-scale fishers and indigenous fishers benefit from these tenurial rights? Let me give you a story. In 2010, some of organizations in Indonesia, including me with my previous organizations before, we are submitted a judicial review to the Constitutional Court related to Regulation number 27 2007 on coastal and small island management. In this way, we sue the government to the Constitutional Court because one of the problem within these regulations are there is a clause that giving an individuals, legal entities, and communities could have a private rights to manage coastal and small island in Indonesia. So based on this issue, then we submitted a judicial review to the Constitutional Court. And after a long process, then on June 2011, the Constitutional Court determined that the rights to commercialize coastal and small islands was invalid because at least two reasons. First reason is the court concluded that a coastal waters commercial use right would lead to the parceling of coastal areas, creating areas of private ownership in the hands of individuals, legal entities, and certain communities. The second reasons are the court also found that the provision establishing the HP3 or a coastal waters commercial use right resulted in the state relinquishing its constitutional obligation to control, and that the arrangement establishing that HP3 did not support to the greatest prosperity of the people. So, based on this decision by the Constitutional Court, then small-scale fishers and indigenous fishers who are still exist could implement freely as long as they are governed by law locally and nationally. They could implement their own rights in terms of tenurial and customary rights in marine resources management. The third question is, what are your recommendations on how to strengthen tenurial and customary rights? Let me read our recommendations for make it clear to all of us. First is modernize customary marine tenure and its traditional management measure, such as sasi laut. This is a name of customary law in Aceh. Term territorial-based fisheries management rights is a promising tool for fisheries management in Indonesia that could contribute to addressing the current major problem of overfishing, especially for small-scale and near-shore fisheries. It could be developed from the existing local or traditional practices, enriched with contemporary science on fisheries management, and careful consideration of the management rights, learning from the annulment of the coastal waters commercial use right by the Constitutional Court in 2011. The second recommendations is this customary marine tenure and its traditional management measure must not be seen as a standalone management measure, but it should be part of a large-scale fisheries management plan at the scale of the Indonesian fisheries management areas. For your information, we have 11 fisheries management areas. This is a geographical unit considered by the Indonesian government to achieve an effective management impacts at a broad scale. The last recommendation, we should consider that the management of coastal areas and small islands, including the utilization of the resources therein, must be based on, we have four important points. First, the benefit of natural resources for the people. Second, the level of distribution of the benefits of natural resources for the people. Third, the level of people's participation in determining the benefits of natural resources. And the fourth, respect for the rights of the people from generation to generation in utilizing natural resources. That concludes this presentations. If you have any questions, I would be happy to open up the discussion later on. Feel free to ask or share your thoughts on this topic. I will do my best to answer them. Thank you all.
Thank you, Halim, for sharing with us the current tenurial system for small-scale and indigenous fisherfolk from Indonesia. In order to share with you the experience in the Philippines, let me call on Ms. Dina Umengan, the current Executive Director of the Tambuyog Development Center, a Philippine non-government organization that caters to the plight and concerns of small-scale fisherfolk. She has been working for 3 decades in the Philippine fisheries industry and a known leader in advocating policy changes for sustainable fisheries management and to improve the situation of the fishing communities in the Philippines. Ms. Omengan served as NGO representative to the National Fisheries and Aquatic Resources Management Council from 2012 to 2016. She is the elected chairperson of the National Banner Program Committee for Fisheries and Aquaculture under the Philippine Council for Agriculture and Fisheries of the Department of Agriculture and the national convener of the Panagat Civil Society Network. Let us all welcome Ms. Dina Umengan.
Thank you, Dennis, for the introduction. Good day, everyone. I'm here to present small-scale fisheries in the Philippines, legal rights and tenure in government policies and programs. In the Philippine context, small-scale fisheries mirrors the nature, dynamics, and spatial condition of municipal fisheries, both capture and aquaculture. Municipal fishing involves the use of fishing vessels weighing 3 gross tons or less. Such activity is allowed within the municipal waters, which covers the 15-kilometer radius projected from the coastal area, including inland waters such as lakes, rivers, and streams. The coastal zone is considered the most productive, resource-rich, and environmentally important ecosystem. The archipelagic nature of the Philippines makes municipal fishing a significant activity for people living in the coastal areas. It is also a major contributor to the national fisheries production. The sectors considered engaged in small-scale fisheries in the Philippines are the fisher folk in municipal and inland capture fishing, fish workers in both aquaculture production and crew in commercial fishing operations, and fish processing sector, and also the women's sector who provide significant contribution to the family livelihood. They are also the social groups mostly affected by poverty, affected by the absence or lack of social protection, and prone to environmental and climate change in view of the dependence of their livelihood on the access to or use of the marine and aquatic resources. The 1987 Philippine Constitution states that the state is the owner of all natural resources. It allows small-scale utilization and gives priority to subsistence fisher folk and fish workers. It recognizes the important role of fisheries in the Philippine society. There are provisions, therefore, that aim to protect this sector. Like use and enjoyment of natural resources is reserved exclusively to Filipino citizens, protect the rights of subsistence fishermen, especially of local communities, to the preferential use of communal marine and fishing resources, both inland and offshore. Provide support to such fishermen through appropriate technology and research, adequate financial production and marketing assistance, and other services. Protect, develop, and conserve such resources. The protections shall extend to offshore fishing grounds of subsistence fishermen against foreign intrusion. Also, fish workers should receive a just share from their labor in the utilization of marine and fishing resources. As a matter of policy in the Philippines, the state not only gives Filipino citizens preference, but also exclusive use and enjoyment of fishery and aquatic resources. The state recognizes the food needs of its citizens and aims for food security through the utilization, management, development, conservation, and protection of fishery resources. To enforce this policy, a law was made in 1998 called Republic Act 8550 or the Philippine Fisheries Code of 1998. The Fisheries Code was amended in 2014 to provide stiffer penalties for illegal, unreported, and unregulated fishing, or IUUF. The Fisheries Code addresses conflict in the use of resources, which is one of the major management issues in capture fisheries. It defined the right of both the municipal and commercial fisher folk and established the limitation of such rights as far as capture fisheries is concerned. It also highlighted the need to adopt the precautionary principle and manage fishery and aquatic resources in a manner consistent with the concept of an ecosystem-based approach to fisheries management and integrated coastal area management. But the clear intent of R855 as amended is to favor the municipal fisher folk, those persons who are directly or indirectly engaged in municipal fishing and other related fishing activities. These are some features of the code. Preferential treatment of municipal fisher folk. Preferential treatment of municipal fisherfolk. The Fisheries Code as amended is generally in favor of the small-scale municipal fisherfolks. It is expressly stated therein that local communities adjacent or nearest to the municipal waters shall be given preference in obtaining licenses and permits to conduct fishing activities. Additionally, the Fisheries Code provides that duly registered fisherfolk organizations and cooperatives are preferred in granting fishery rights. On the matter of having permission to use public land for fish pond purposes, it is stated in law that tidal swamps, mangroves, marshes, foreshore lands, and ponds suitable for fishery operations may be used by qualified fisherfolk cooperatives and associations for fish pond development. The Fisheries and Aquatic Resource Management Councils are given by the Fisheries Code a diverse range of responsibilities depending on their jurisdiction as a unit. For example, the National Farm Sea has the function of assisting in the formulation of national policies, assisting in the preparation of the National Fisheries and Industry Development Plan, and performing such other functions as may be provided by law. The municipal and city farm seas have the responsibility of assisting the preparation of a municipal or city fishery development plan and recommending the enactment of relevant fishery ordinances and also assisting in the enforcement of fishery laws. It also advise the Sangguniang Bayan Panglungsod or the legislative branch of LGUs on fishery matters. The law demands that farms shall be formed by fisherfolk organizations and cooperatives and non-government offices to be assisted by the LGU and other government entities. There are, however, specific members identified by law to compose the different farm seas. The National Farm Sea shall be composed of the country's Undersecretary of Agriculture. It shall be composed of the Undersecretary of the DILG or Interior and Local Government, 5 members representing fisherfolk and fish workers, 5 members representing commercial fishing and aquaculture operators and the processing sectors, 2 members of the AHDIM, and 1 representative of NGOs involved in fisheries. The multiple post-harvest assistance to fisherfolk are available in the law. The Fisheries Code provides that municipal and small-scale commercial fisherfolk shall enjoy at least 10% of the credit and the guarantee funds of government financing institutions that are made available for post-harvest and marketing projects. It is also sector, other concerned agencies, and the farm seas in establishing post-harvest facilities for fishing communities consistent with the comprehensive post-harvest and ancillary industry plan. State effort to provide settlement areas for fishing communities is embodied in the law. According to the Fisheries Code, certain areas of the public domain shall be reserved for the settlement of municipal fisherfolk. The Department of Agriculture and Bureau of Fisheries is mandated to establish a fisherfolk settlement area near the fishing grounds. Fisherfolk registration. The registration of fisherfolk is mandated by the Fisheries Code, which requires the LGUs to maintain a registry of municipal fisherfolk to determine prioritization among them, limiting entry into the municipal waters, and for monitoring and regulating fishing activities. This is done annually or as necessary in consultation with the farm sea. The registration also includes the type of gears used and other boat particulars. But for purposes of regulating access to fisheries, the registration is intended to determine the basis for priority access among municipal fisherfolk to engage in fisheries activities for management, regulation, conservation, and protection, and establish comprehensive fisheries information. It should be noted that registration is not equivalent to a permit or license. Such should be obtained by the registered fisherfolk or operator. Integrated management of fisheries. In terms of managing the fisheries and aquatic resources, management intervention by LGUs or local government units should be consistent with the concept of an integrated coastal area management in specific natural fisheries management areas, appropriately supported by research, technical services, and guidance provided by the state. The Fisheries Code as amended provides that the management of contiguous fishery resources such as bays, which straddle several municipalities, cities, and provinces, shall be done in an integrated manner and not based on political subdivisions of municipal waters in order to facilitate their management as single resource systems. The LGUs which share or borders such resources may group themselves and coordinate with each other to achieve the objectives of integrated fishery resource management. Regulations and prohibitions of activities within municipal waters. The Fisheries Code provides for various regulatory measures on access to fishery resources and for its protection and conservation. Prohibitions relevant to fishing within municipal waters are as follows. Imposition of the passive gears as the type of gear allowed for fishing within municipal waters, imposition of harvest control rules and reference points in a fishery management area or fishery, declaration of closed season by BIFAR or through the LGUs, which is considered a serious violation, prohibition or unauthorized fishing such as fishing without license or commercial fishing in municipal waters, prohibition on destructive fishing methods such as the use of explosives, noxious substance, or electricity, fine mesh nets, ban on muroami, other methods, and gear destructive to coral reefs and other marine habitat. Use of super lights or fishing light tractor, protection against mangrove conversion, and protection of endangered species, among others. Next. RA 7586, as amended by RA 11308, is the act providing for the establishment and management of National Integrated Protected Area System, or NIPAS law. Said law is a countermeasure to the continuous depletion of marine resources, among others, due to unsustainable fishing practices. The state recognizes that the increase in population is tantamount to a greater resource exploitation that creates the urge to ensure environmental protection for the sake of the next generation of the Filipino people. Hence, the law creates a system of protected areas which will be conservation areas where management regimes will be implemented by the LGUs. Decent work in fisheries and the Department of Labor and Employment, Department Order 156-16, to further protect the interests of fish workers, DOLE 156-16, or the rules and regulations governing and the working and living conditions of fishers on board fishing vessels engaged in commercial fishing operations. The said order include the terms and conditions of employment of fishers, their compensation scheme, rules on occupational safety and health, provision of social protection benefits, and the implementation of a livelihood and support program. The policy upheld by the government in the implementation of this department order relates to the regulation of the relations between fish workers and employers consistent with the rights of labor and the rights of enterprise, the guarantee and respect the free exercise of commercial fishers to unionize for bargaining and mutual aid and protection, and the assurance that vessels used in fishing are compliant with safety standards and that occupational safety and health standards are also observed. Social Reform and Poverty Alleviation Act. Republic Act 8425, or the Social Reform and Poverty Alleviation Act, enacted in 1998. It operationalizes the commitment of the state to address prevailing poverty issue among the basic sectors. The segment of the population belonging to the basic sectors are the disadvantaged sectors of Philippine society, namely farmer peasant, artisanal fisher folk, workers in the formal sector and migrant workers, workers in the informal sector, indigenous peoples and cultural communities, women, differently abled persons, senior citizens, victims of calamities and disasters, youth and students, children and urban poor. Fishers covered by the law are municipal small-scale or subsistence fishermen who use fishing gear which do not require boats or which only require boats below 3 gross tons. The National Anti-Poverty Commission, or NAPSI, was created by the law. The President of the Philippines chairs NAPSI. There are 2 vice chairpersons, one from the government sector and another from the basic sectors, while the commission is supported by the Secretariat. There are also various government programs in support of small-scale fisheries and small-scale fisher folk. These are 4Ps, the Pantawid Pamilya Pilipino program, more commonly known as 4Ps, is a government program that grants the poor Filipino cash grants. It aims to improve the health, nutrition, and education of children through the said cash grants. The Philippine Development Plan for the year 2017-2022, fisher folks are given priority in accessing economic opportunities with the following strategies: improvement of agriculture, forestry, and fisheries productivity within ecological limit, increase of agriculture, forestry, and fisheries-based enterprise, increase the stakeholders' access to value chains, increase farmers and fisher folks' access to innovative financing, increase agriculture, forestry, and fisheries stakeholders' access to technology, and increase and protection of the access of small farmers and fisher folk to land and water resources. Through these strategies, the government hopes that the fisher folk and other marginalized sectors are included as active participants and beneficiaries of development opportunities and economic progress. The National Fisheries Development Plan, as per Fisheries Code, the Bureau of Fisheries and Aquatic Resources shall prepare and implement a comprehensive national fisheries industry plan, which it did first in 2006. The CNFIDP served as a framework to guide the development and long-term sustainability of benefits derived from fisheries. It contains elements on physical infrastructure, support expansion activities, marketing assistance, resource rehabilitation, and habitat restoration. Climate change adaptation and mitigation. The Philippines has been responsive to climate change. A number of laws have been legislated to mitigate and adapt to the impacts of climate change. With application to fisheries, vulnerability assessments have started in government projects and programs for adaptation planning. Fishing communities are the most vulnerable sector in our society. People's Survival Fund. RA 10174 is an amendment to Climate Change Act of 2009. It provides for the creation of a financing mechanism to enable the government to address the problem of climate change. One of the uses of the fund is to support adaptation activities of local governments and communities. Coastal and marine resources are among the climate-sensitive sectors that should be prioritized by the Climate Change Commission in terms of providing access to climate financing for adaptation activities of the local government units and communities. The law mandates the participation of vulnerable and marginalized groups, among others, in the identification, monitoring, and evaluation process of the adaptation projects to be supported by the fund. Local governance of small-scale fisheries. Provisions on local governance of small-scale fisheries are invariably provided under the Local Government Code of 1991. The local autonomy granted to local governments by the said national law created the legal infrastructure for the local governance of small-scale fisheries. One of its policy objectives is to provide the local government units with meaningful local autonomy to enable them to be self-reliant and effective partners for the attainment of national goals by instituting a responsive and accountable local government structures with decentralized powers, authority, responsibilities, and resources. The LGUs are divided into province, city, municipality, and barangay. The decentralization of the management of the fisheries from the national government to the local government units was given impetus by the Local Government Code of 1991 and that was further elaborated by the Fisheries Code of 1998 as amended. Women in fisheries. The women in fisheries perform activities in the pre and post-harvest or participation in actual fishing activities are limited to ones that may be done near shore, mostly because in fishing communities, they need to remain within household premises so that they can attend to their responsibilities at home. The Fisheries Code recognizes the representation of the women's sector in various levels of farm seas, from national down to barangay. Republic Act 9710, or the Magna Carta of Women, provides a broad recognition of the rights of women at levels of policy formulation, planning, organization, implementation, management, monitoring, and evaluation of all programs, projects, and services. It shall support policies, researches, technology, and training programs, and other support services such as financing, production, and marketing to encourage active participation of women in national development. Utilization of public fish fund. Through the tenurial instrument, Aquaculture Stewardship Contracts or Aqua Silviculture Stewardship Contract, the Fisheries Administrative Order 197-1 issued by the Department of Agriculture, Bureau of Fisheries and Aquatic Resources gives preferential treatment to qualified fisherfolk cooperatives and associations and micro, small, and medium enterprises for the use of public land for mangrove-friendly aquaculture. Community-based forest management. ABFM is a program of government to encourage reforestation and sustainable management of forests, including mangrove areas. Community and fisher folk organizations is entitled to develop and use a forest area or mangrove area and its resources for up to 25 years through the issuance of its tenurial instrument called CBFMA or Community-Based Forest Management Agreements. In summary, small-scale fisheries is recognized and adequately supported by existing laws, policies, and programs in the Philippines. The main legal foundations are laid down mainly in the 1987 Philippine Constitution, Fisheries Code as amended or Republic Act 10654, and the Local Government Code of 1991. All other laws and policies are with specific provisions and broad policy framework that strengthen the rights and tenurial security of small-scale fishery sector. What are the other benefits derived from these tenurial rights? First, preferential treatment on access and utilization of municipal waters. The Philippine Fisheries Code or RA 8550 as amended favors the municipal fisher folk. Also, part of the policy declarations of said law is to protect the rights of fisher folk, and they are given priority in the preferential use of the municipal waters, subject to certain limitations. The law also provides them the needed support, including women and youth sectors. On recognition of women in fisheries, the Fisheries Code as amended generally does not discriminate against women in fisheries, but recognizes the representation of the women's sector in various levels of pharmacy from national down to village level. Also, it recognizes the recognition of the rights and protection of women in fisheries is provided by the Magna Carta on Women. On capacity building assistance, there are training courses available for small-scale fisher folk in government programs like sustainable fisheries-related policies, technologies on fish capture like gears, making, post-harvest technologies, and aquaculture. On post-harvest, most of the training participants are women, especially in seaweed development program and other processing techniques. Other technical assistance from government support programs includes rapid assessment for the identification of fish sanctuaries, provision of buoys and guardhouse, and deputizing fish wardens and trainings for pharmacies. On support for community fish landing centers, CFLCs are constructed in more than 700 coastal municipalities, which the fisherfolk communities can use not only for fisheries management activities, but also for marketing, training, and other post-harvest activities, but limited budget as of now to cater for all. On fisherfolk settlement areas, the law already provides for the establishment of fisherfolk settlement areas, but the government is yet to issue the implementing guidelines of these tenurial rights of small-scale fisherfolk. If implemented, tenure on settlement areas for fisherfolk families will be secured. Policies in support of the basic sectors, which include the small-scale artisanal fisherfolk in the Philippines, have strong legal foundations which define institutional support. Improvement is needed for its implementation and its translation to concrete economic gains and social protection for the sector. Despite the laws on social protection and poverty alleviations, specifically targeting the SSF, among other groups, comprising the basic sectors, fisherfolk sector has the highest poverty incidence at 40% compared to the national average of 26.3. Here are some recommendations for further strengthen the rights of small fishers and the tenure system favorable to them. On governance of tenure of small fishers, the issue of fisherfolk settlement needs to be addressed to secure tenure of fisherfolk. As mentioned earlier, DA should enact a department order on the establishment of fisherfolk settlement and to ensure the compliance of the different government agencies in the implementation of fisherfolk settlement program. Address the gaps in municipal water delineation, including fast-tracking of delineation of waters of municipalities without offshore islands, and come up with guidelines for municipalities with offshore islands. Customary rights to ancestral waters should not be compromised. Sectoral participation of indigenous people in legal and government processes should be strengthened. Social development, employment, and decent work, BIFAR should continue to pursue its national registration programs, specifically Fish R for municipal fisherfolk, Boat R for fishing vessels, Gear R for the fishing gears, and Aqua R for aquaculture farms. These registrations are important to identify the small-scale fisherfolk to be assisted. Also, BIFAR should continue to conduct technology training courses and provide assets like the construction and provision of fiberglass boats instead of wooden boats. BIFAR should continue to assist fisherwomen through training programs on post-harvest technologies and the continuing registration of women as fishers. Community fish landing centers was envisioned to reduce post-harvest losses as well as venues for skills training or on disaster-resilient fisheries-based livelihood and resource management, such as monitoring fish catch and stock assessment. They are to be eventually managed by fisherfolk groups. Ensuring the operations of these centers indeed benefit the fisherfolks and will help improve the social and economic situation of the small-scale fishers. The National Farm Sea can be a platform for monitoring the FLCs. Fisherfolk beneficiaries should also be given full recognition of their roles at all levels of CFLC implementation with corresponding support for operations. The Memorandum of Agreement should specify roles of beneficiaries in the implementation and operation of CFLCs. Decent work, aside from ensuring the promulgation of beneficial policies for fish workers, such as Dual Department Order 156-16, programs should be formulated and set in place to ensure decent working conditions and fair income for small-scale fishers involved in the whole fisheries value chain. Disaster risk and climate change. At the local level, there is a need to undertake policy advocacy to secure fisherfolk tenure in times of disasters and climate change impacts. Meanwhile, at the national level, there is a need to undertake policy advocacy to examine sectoral impacts of disasters and climate change and implement adaptation and resiliency programs for fisheries and aquaculture. There should also be interagency collaboration for holistic approach to the fisheries issues, where each agency contributes efforts based on their respective mandates. There should be delineation and harmonization of roles for more holistic approach to fisheries issues. Creation of a separate Department of Fisheries. The Philippines is a maritime country. The small-scale fishers believe the creation of a separate Department of Ocean, Fisheries and Aquatic Resources is needed to manage water resources or fishery resources in the more than 7,000 islands of the Philippines. With that, thank you very much. Maraming salamat.
Thank you very much, Dina. I'd like to point out a similarity on how the Tambuyog Development Center and Rare Philippines view tenurial rights for small-scale fishers. Of course, Philippine laws recognize and in fact empower small-scale fishers. But the actual granting of rights to utilize resources, for instance, can be done through the granting of fishing license. And before one can get a fishing license, one needs to be a registered fisherfolk. We see the registration and licensing system in the Philippines benefit both the small-scale fishers themselves and the local government units. For the small-scale fishers, once registered and licensed, they are now counted officially as fisherfolk. Aside from that, they become part of the solution as they become an active participant to the whole management system of fisheries. They also become role model to their fellow fisherfolk as they follow the rules and comply with the policies set by the community and the government. And lastly, they become a priority beneficiary for government's program. Registration and licensing is also beneficial to the local government units. Through the registration and licensing system, the LGUs get the relevant information about the resource users, which they can use for policies and programs. Licensing can also be a viable resource generation scheme for the LGUs. That is why we at RARE recommends to make registration and licensing easy, which means E for efficient, A for accessible, S for simple, and Y for your very own. Now, to give us their experience and customary rights on indigenous fishing communities in the Philippines, let us all welcome Mr. Dave De Vera of the Philippine Association for Intercultural Development. Dave De Vera is a community mapper and development worker. He has been working with indigenous communities for the past 34 years. Dave heads the PAFID. He is also a member of the Council of Elders of the International Community Conserved Areas Consortium and an advisor to the Bukluran, a national federation of indigenous peoples protecting their traditional conservation areas. PAFID is one of the pioneers in the mapping of indigenous territories in Asia, starting its community mapping work in 1992. To date, PAFID has mapped out at least 1.7 million hectares of ancestral lands and domains in the Philippines. PAFID has also been in partnership with indigenous communities in Myanmar, Nepal, and India, where it has provided capacity building support to indigenous and local mappers. Founded in 1967, PAFID is an NGO with a multidisciplinary staff, most of whom are indigenous peoples who are engaged in the development of indigenous social organizations, ancestral domain management, community-based natural resources management planning, community mapping, agroforestry, technical services, and policy advocacy, among others. Again, let us all welcome Mr. Dave De Vera.
Good afternoon. Good afternoon, everybody. Thank you, Dennis, for the introduction. Today, I have been asked to make a presentation on ancestral waters and indigenous communities in the Philippines. My presentation will give you an overview of the legal policy framework of ancestral waters in the Philippines, as well as a short case study of an indigenous community that actually filed for a claim over ancestral waters. Are customary rights of indigenous fishing communities in the Philippines legally recognized? Yes, under the Indigenous Peoples' Rights Act of 1997 or Republic Act 8371, traditional fishing grounds in the ocean and coastal areas as well as inland bodies of water are recognized as part of the ancestral domains of indigenous communities in the Philippines. Indigenous Peoples' Rights Act or IPRA defines the nature and coverage of ancestral domains of indigenous peoples. Ancestral domains, according to the law, refers to all areas generally belonging to indigenous cultural communities which comprise land, water, coastal areas, and natural resources that are inside. The Indigenous Peoples' Rights Act provides the legal basis for the inclusion of ancestral waters in the filing of claims of ancestral domains. Under the law, indigenous fishing communities can actually file claims over the ancestral waters and secure a certificate of ancestral domain title. The ancestral domain title provides the legal ownership of the ancestral domain of the traditional rights holders of the community. The ancestral domains is governed and managed by the traditional governance structure of the indigenous community. Today, there are 8 ethno-linguistic indigenous community rights holders with ancestral waters. These are the Ivatan, the Agta, the Aita, the Agta Tabangnon, the Bantuanon, the Tagbanwa, the Palawan, and the Subanon. their, their ancestral domain titles are spread all over the country. Now, some very important figures. The total marine area covered by titles total to at least 805,896.70 hectares. Now, this is at least 15% of the total coverage of approved titles issued to indigenous communities in the Philippines. To date, there are nearly 3 million hectares of ancestral domains that have already been given titles and are owned by indigenous peoples. Now, I'm going to show you where these titles are that include parts of the ocean. Up in the northern part of the Philippines, you have the Ivatan seascape, and then at the lower part of the slide, you have the coastal areas along with the inland areas of the Agta community. In the central part of the Philippines, you have areas owned by the Agta in the western section, and then the Aita in the eastern section. Further down south, you have you have a title over an island in a substantial portion of the ocean of the areas owned by the indigenous peoples in Romblon. Then you also have a substantial coastal area and inland area owned by the Agta communities in Bicol. In Palawan, the last frontier of the Philippines, you have the most number of ancestral domains which include the ocean. And then further down in Mindanao, in Zamboanga, you have several titles that have been issued to the Subanen indigenous communities that include a substantial portion of the ocean. One of the bigger claims also is the Samal ancestral domain title, which includes all of the waters of the ocean ringing the island. Samal Island is one of the more famous and popular tourist destinations in Mindanao. Now, I'm gonna show you, this is the case study that I mentioned earlier, so that we'll understand the actual experience of a community that tried to reclaim the lands in their customary marine areas. These are the Tagbanwa in Coron Island. I was part of this initiative from the start till the end. This happened in the early part of the 2000 all the way to the middle part of the decade. The Tagbanwa inhabit the northern portion of the Calamianes Island group in the province of the Philippines. Now, in this picture, these are the elders who are called the Mamepet. They are the traditional elders of the community. The Tagbanwa are subsistence fisher folks and seasonal farmers and bird's nest gatherers. They gather bird's nests and sell them to Chinese middlemen in order to augment their income from seasonal farming and fishing. Now, for geographical context, this is the Philippines, and in that small section in central Philippines, a small island called Coron Island. Now, this is a bigger picture of Coron Island. Unfortunately, there are clouds, but there are 11 lakes inside the island, 5 of which are brackish water. Oh, this is one of the lakes, Kayangan Lake, and one of the more famous lakes in the Philippines that is regularly visited by tourists for its beauty and cleanliness. In the mid-1990s, as the tourism industry boomed, there was tremendous encroachment into their territories. Many speculators came in and started illegally titling islands, and then started selling islands without the consent or even knowledge of indigenous peoples. This really jeopardized the ability of the Tagbanwa to restrict entry into their sacred lakes. The lakes are one of the most important areas of the community because these are considered sacred. As the demand for food increased because of the increased economic activities, a lot of the migrant fishermen resorted to very destructive illegal fishing methods, and this really took its toll on the traditional fishing grounds of the Tagbanwa. This is an actual picture that I took of one of the coral reefs that ring the island that had been damaged due to cyanide fishing. In 1993, because of the pressure brought about by migrants and the speculation of middlemen, the community decided to file a formal claim for the ancestral lands and waters with the government of the Republic of the Philippines. Now, the ancestral water covered the whole of the ocean that immediately surrounded the ancestral domains. This included parts of the ocean which are past and present fishing grounds, the coral reefs and passageways used in navigating their fishing travels back to their village. To map the ancestral waters, the Tagbanwa used GPS receivers located and marked the traditional corners And this included getting GPS fixes on coral reefs, sacred grounds, and the Burial Islands. The Tagbanwa mapped the edges of the coral reefs, the passageways for boats, unique rock outcrops. There are places in the ocean with sudden drops, intersection between fresh and salt water, and the boundaries among villages that are usually agreed as the common fishing grounds and mangrove areas. Most important were the locations of the sacred panyans, which they believe is the nest of the giant octopus, and the amlarans, or the resting areas of the spirit. Now, on the upper left side is a picture of a bulbous coral formation, which is a panyaan, which they actually believe is the nest of the sleeping giant octopus. On the lower left side is a rocky outcrop, which is considered as an amlaran, which is a resting place for the spirits, and this is actually a burial ground. Now, this is the map, one of the very first maps of ancestral waters in the Philippines that we finished in 1997. If you take a look, the northing symbol is not a traditional symbol, but it is the four-tentacled giant octopus, which they consider as the most sacred spirit animal uh, in their place. In 2001, the recognition certificate was formally converted into a title that was awarded to the Tagbanwa, recognizing their ownership of the ancestral lands and waters. This is a copy of the actual original certificate of title of the island, which includes a substantial portion of the ocean. Now, what are the benefits from the recognition of tenure over ancestral waters? One, the title was used for negotiations. For example, in the early part of 2000, the Royal Dutch Petroleum Company wanted to put a pipeline to transfer its natural gas from one of its offshore rigs all the way to the mainland, and the community negotiated with them. And as a response, the Royal Dutch Company said that the indigenous Tagbanwa were worried for the pipeline route, so they avoided the ancestral waters. They reset the whole route of the pipeline, and as part of the deal, the Tagban were also able to get some concessions and got some livelihood support. Further, was just a couple of years ago. Nickelodeon, owned by Viacom International, wanted to build an underwater theme park. And again, the Tagbanwa were at the forefront of the opposition, and they said that this is our ancestral waters, it is titled, and they formally filed a petition opposing the construction of the underwater theme park. As a response, Viacom International Media Network said that it had abandoned its project and stopped support for the project. Also, another important benefit is that with the title, the indigenous community that Tagbanwa were able to negotiate and link with with government agencies as well as the police and the military, along with several international donors, for them to recognize and support the policies of governance and management of the ancestral waters. This has been a very, very important step towards recognizing the governance authority over the ancestral waters. Also, another important feature is that uh, the community has been able to take control of the tourism industry that comes into the island. Before, they were just passive observers, not earning anything and being exploited, but now they control the entry of all tourists to the island. Uh, Visiting Coron Island is one of the must-do activities, and it's considered the crown jewel of tourism in northern Palawan. All tourists have to pay directly to the community to enter the lakes. The Tagbano have also established a scholarship fund, medical fund, and livelihood funds from the tourism earnings. Of course, there are always problems and issues. No? These are just some of it. Number one, there is always the overlapping jurisdictions and coverage among government agencies. So there is a lot of confusion on who they should be dealing with. There is limited knowledge and information of the public as well as government officials regarding the nature of ancestral waters and the rights of indigenous communities. This is the cause of some of resentment and blowback from many from parts of the public who refuse to recognize the rights of the community over the ocean. There is resistance, and then there is limited capacity of indigenous communities to protect their ancestral waters and assert their governance over it. It's not simple to protect and govern a huge area, and this responsibility is huge for an indigenous community. Now, what are the recommendations? No? These recommendations have been culled from an actual community dialogue conducted several months ago where the people discussed the ways forward. One is to conduct continuous and sustained information and education campaign to inform the government and the public of the nature of ancestral waters and the rights of indigenous peoples. The second one was to engage government policymakers to facilitate the harmonization of overlapping policies and jurisdictions among the agencies because this affects the rights of indigenous peoples over their ancestral waters. And then the capacities of indigenous communities should be built and strengthened to enable them to assert their rights over the ancestral waters and to lobby and secure support for indigenous communities to enable them to effectively govern and manage their ancestral waters. Um, I hope that with my presentation, I was able to give some light on the nature of ancestral waters claims in the Philippines. And again, I thank the organizers for giving me this opportunity to share our experience. Good afternoon, and thank you very much.
Thank you very much. Maraming salamat, Dave. That's very informative and very interesting presentation regarding the ancestral waters in the Philippines. And I think most of organizations here are part of an advocacy in the Philippines wherein we're working with the Philippine government to come up with a guideline uh, that would operationalize and recognize as well as strengthen the tenurial rights of both small-scale fishers and indigenous fishers in the Philippines. So we're now in the session of open forum. So may I ask all the panelists to turn on their camera so we can address some of the questions that may be raised today. I would like to ask Dave and then Halim. Thank you very much. So thank you very much for the three panelists, and we appreciate all the presentations and the informations that you have shared. So I'm looking now at the chat group as well as at the YouTube. We're monitoring both of them, and we have one question that we would like the panelists to answer. This is about the International Year of Artisanal Fisheries and Aquaculture that will happen in 2022. That's next year. So this is also an opportunity that was provided to us by the Too Big to Ignore in relation to the IAFA 2022. So my question is, if you have any message for our global leaders regarding small scale and indigenous fisher folk in the world. Do you have any message for them for the IAFA 2022? So I think I'll give the floor to Ms. Dina Omengan of the Tambuyog Development Center. Dina.
Yes, thank you, Dennis. You're asking about our message, no, to global leaders, no, in time for the International Year of Artisanal Fisheries and Aquaculture. Well, as seafood is one of the major traded goods globally, and most of these come from the small-scale fisheries. I think now more than ever, more support is needed to address their overall well-being as well as their families. Social and environmental safeguards must be present in all programs and projects affecting coastal communities. That's it.
Thank you, Dina. Then I'll ask Halim. Halim, if you have any message for our global leaders for the IAFA International Year of Artisanal Fisheries and Aquaculture in 2022. Go ahead, Halim. You're mute, Halim. Can you open your mic?
Yeah, thank you, Dennis. The message that we need to raise to the global leaders, and especially to our national and or local leaders, are they should back to the real perspective in managing our marine resources, especially if we look back to the FAO statistic in the 2020. They said that we are in a dangerous situation while the resources are declining, especially of fisheries resources. So based on this fact, so we need to respect and implement to our small-scale fishers and indigenous fishers' right in managing their ancestral marine areas and its resources. So every plan of development should ask a permit first from the small-scale fishers and indigenous fishers along the world, especially in Indonesia and the Philippines. Thank you, Dennis.
Thank you, Halim. For Sir Dave De Vera of PAFID, can we have your message?
Very briefly, I just want to say that for global leaders, there is no other choice. You should start recognizing the tenurial rights of indigenous fishers and small-scale fishers in the marine areas. There is no other way. We are losing our resources so fast. Everybody has tried every possible formula on how to fix the problem, but it has all failed. The last remaining chance that we have is to recognize the rights of the small-scale fishers and the indigenous peoples because they hold the key. They're not going anywhere. They live there, they will die there. So we have no choice but to recognize their tenurial rights.
Thank you very much, Sir Dave, for that inspiring words. And thank you very much to our panelists. Just to summarize all the things that we have discussed today, I think we are one, both in Indonesia and the Philippines, that tenurial and customary rights are written in our laws, right? It's written in our constitution, it's written in our national laws. But the problem is on the implementation, as we always said. I think we have to recognize that and we have to do something about that since, as Sir Dave said, we have to do it now. No? So we have to address that problem since we're also facing the wicked problems on overfishing, illegal, unreported, and unregulated fishing, as well as climate change. So I think we all have our discussion in each of our country, and we're looking at the possibility of having to achievements of this advocacies. And then for other questions, if you have anything, I have here a question from one of our participants. Maybe this will be the last. Is there a proposed legislative measures to issue tenurial instruments to artisanal fishers similar to CAD-T of the IP? I think that's the question. If the indigenous peoples have the CAD-T in the Philippines, do we have the similar tenurial instrument in the Philippines and in Indonesia for a small scale? Anyone?
Well, then,
Yeah. Yes, Dina.
well, it's already in the law that the 15-kilometer municipal waters is the preferential users are the municipal fisheries. I think there's no need to issue title on that. And the first 10 kilometers actually of the municipal waters are exclusive, no, for the use of our small-scale fisher folk or the municipal fishers. Yeah, that's it. That's my reply.
Thank you, Dina. Halim, do you have anything to say?
Yeah, based on our constitution and national laws, as same as what Dina has said before in the Philippines, the same situation are also happen in Indonesia. That's 4 miles from the coastal areas should be quote unquote privatized for the small scale fishers and indigenous fishers. So every permits or any proposal from the investor or the government in terms of development project should be ask the permit first from the small scale fishers and indigenous fishers. If they say no, so everything should be no.
Yeah.
That's my comment for the question, Dennis. Thank you.
Yeah, thank you, Halim. I think that's also one of the contentious issues that we're currently discussing with the Philippine government, right? The proper tenurial instrument for municipal fisher folk, for them to have access and security in terms of their utilization of the coastal and fisheries resources. And I think I would have to agree with Halim that in the case of the small scale fishers, I think the license would be the form of a tenurial instrument. Of course, that license would have to be based on legal framework like the national law as well as the ordinance of the local government units. Thank you very much for that question, and thank you very much for all the participants who have joined us in Zoom as well as in YouTube. And for the participants that still have their questions in their mind, we can be contacted through these following details. So we have the contact details of the organizers for this session. Thank you very much. So we have the Panagat Network Center of Maritime Reform for Humanity, Tambuyog Development Center, PAFID, and Rare Philippines. Again, thank you very much, and we hope to see you in other activities in relation to the International Year of Artisanal Fisheries and Aquaculture. Happy Oceans Day, and thank you very much. Maraming salamat po.
Thank you, Dennis. Thank you all.
Thank you all.